Well, hello there. How is everyone? I hope you are well. You amazing, amazing people. You're still looking absolutely amazing today. So I'm guessing Monday has been going well. Well, the morning anyway. Well, I hope the rest of the day continues and you continue looking amazing. I may do another video today if something else comes out. It's quite early and it's an early Monday, so there isn't much that has currently been reported upon. But what we are talking about in this video is Alex Murdaugh, because there has been things going on in the Alex Murdaugh case. Some of you may know, some of you may not know, but it was recently attempted to get him another trial on the basis that the original one simply wasn't fair. Some of you will think, what an absolute lunatic. Some of you will think, actually, is valid. You know, at the end of the day, whether you feel someone's guilty or feel someone's innocent, they have a right to a fair trial, don't they? At the end of the day, that's it. So we look into it, because currently it would appear that it's been turned down. They're saying, no, Alex Murdaugh, we don't need to give you another trial. The first one was fine. But let's have a look at some arguments to it. So look, this is the Washington Post, and it's saying that Alex Murdaugh didn't get a new trial. But he might yet. Will he get a different outcome? That's a different matter. And it's saying Columbia, South Carolina, no one really expected Judge Jean Toll to grant convicted murderer Alex Murdaugh a new trial based on allegations of jury tampering by Rebecca Hill, the Colleton County Clerk of Court. Toll had already made clear in a pre-hearing that she would make her decision based on a federal ruling in South Carolina versus Green. The defense would have to prove not only that there was interference with the jury, but also that the jurors were influenced by it. At a hearing on Monday at the Richland County Courthouse, Toll repeated her intention. Draw from that precedent, she alone would pose a few narrowly defined questions to the 12 jurors who convicted Murdaugh of murder last March. Did they stand by their verdict? Was it based only on evidence, testimony, and law? Did Hill talk to the jurors about the case? Were they influenced by what she said? Toll would also question Hill under oath. Before I begin the near impossible task of reducing the saga to a few hundred words, allow me to summarize the preliminary conclusions from the hearing. There was jury tampering. Hill is a liar. No one who bet on Monday's rule and lost money. The truth is, no one wants a new trial except the defendant and his legal team. Murdaugh's 2 convictions for the slayings of his wife, Maggie, and his youngest son, Paul, were the result of a 6-week trial, countless witnesses, reams of evidence, and a nearly airtight prosecution by the state of South Carolina. A retrial would be costly to taxpayers. Again, victims and families would have to suffer through the rehash of their worst nightmare, and lead prosecutor Croydon Waters, dubbed the AI of lawyers by a television producer, isn't going to get worse at his job. Moreover, for the murders to have been committed by someone other than Murdaugh, the killer or killers would have had approximately 4 minutes to materialise at the family dog kennels, toting 2 long guns, exactly like the 2 owned by Murdaugh, shoot the mother and son, and then disappear apparently forever. Unlike Murdaugh, who was demonstrably present at the time. Even so, everyone deserves a fair trial, right? Did the 12 jurors, without taking notes, follow and absorb the 6 weeks of mind-bending minutiae, the mind-bending minutiae that Waters delivered, including his down-to-the-second tick-tock of the crime, before delivering their verdict in just 3 hours? Or were they influenced by Hill, as the defense has alleged in a 65-page affidavit? Among its allegations was that Hill spoke to the jurors about the case during the trial and that she drove one juror home after court. She also made some damning admissions in a book she co-authored and allegedly told jurors they would have to reach a verdict by 10 p.m. or spend the night in a hotel. Allegedly, too, Hill told the smokers among the jurors that they couldn't take a cigarette break until they reached the verdict. And I can tell you this, from my long ago years of smoking, I'd have convicted Snow White for stealing apples and sleeping on the job after 1 hour without a smoke. How true is that? Under oath, the demure Pearl Stranded Hill denied all of the above, but she was, at least in some instances, lying. The genteel Toll more charitably said that Hill was not entirely credible. In fact, four jurors, including an alternate juror, said that during the trial, Hill urged jurors to not be fooled by the defence, to watch his actions, and to watch closely, referring to Murdaugh. Only one juror, known as Juror Z, testified to both hearing Hill's comments and being influenced by them. To me, it felt like she made it seem like he was already guilty, she said on the witness stand. The defence must have struggled to stifle cheers at this, until the prosecution pointed out that Juror Z had said different things in two separate affidavits. In the first, she said she felt pressured by other jurors. In the second, signed Monday morning before the hearing, she claimed that she had been influenced by Hill. Hill also testified that she had never spoken to the so-called egg lady juror, whom Hill was instrumental in getting dismissed from the jury. Toll quickly corrected the witness on this, pointing to a hearing in which presiding Judge Clifton Newman expressed unhappiness with your talking to the juror before he had chance to. Egg lady, so named because she once brought eggs to the jury room, apparently wasn't convinced of Murdaugh's guilt and reportedly said so to two people outside the courtroom. Newman told her she might have done nothing wrong before gently sending her home with her eggs. In her book, to which Toll referred several times, Hill committed unpardonable sins, fabricating, embellishing, and even plagiarizing. If ever there was a tale that needed no embellishment, the Murdaugh story it is. Hill explained her author's crimes as poetic ease, which would make the story better. Toll concluded that Hill decided to write the long book before the trial began, and she was attracted to the siren call of celebrity. The defense viewed the book as evidence of Hill's motive in both tampering with the jury and orchestrating Egg Lady's dismissal. The theory here is that Hill needed a guilty verdict to sell the book, which is plausible given testimony from Barnwell County Clerk of Court, Rhonda McElveen, who assisted Hill throughout the trial. McElveen, whose deadpan delivery could bring mirth to the merciless, testified that Hill had spoken to her several times about writing a book together. She needed a lake house and I wanted to retire, she equipped. McElveen, who did not work on the book, said she told Hill that a guilty verdict would make it more marketable. So she testified that Hill did give the juror a ride home and that she scolded her for it. Don't tell me you gave a juror a ride home, McElveen recalls saying to Hill the next morning. I did, Hill reportedly said, but I had a bailiff with me. I wonder what they talked about in the car. Cookie recipes? I think not. A few minutes before 5 p.m. on Monday, Toll announced a 15-minute break while she considered her ruling. At 5:14, she emerged to read a statement that seemed too comprehensive to have been written so quickly. The defense will surely note this on appeal. I confess to some unease with Toll's decision, a feeling similar to what I and others experienced when the jury took only about 3 hours to convict Murdaugh last year. I wonder why the clerk's dissembling doesn't impeach her credibility across the board when 4 of 13 jurors confirm that the defense claims isn't that tampering. It would have been enough under a different Supreme Court ruling had Toll followed it instead of Green. In Remmer v. United States, which predates South Carolina v. Green, the court ruled that any inappropriate communication with jurors is presumed to be prejudicial. Under Remmer, it would be up to the state to prove that Hill's communications were not. If we take nothing else from this latest chapter in the Murdaugh saga, it is that our judicial system needs significant updating to deal with social media and to make jury instructions ironclad. Jurors need to be instructed early, clearly, and repeatedly, and that they are not to access any media or talk to anyone, gag order, or face being charged with contempt of court. I believe in Murdaugh's guilt, but I also believe that Hill engaged in jury tampering. She might not have persuaded the jurors in this case, but she contributed to circumstances that give us reasonable pause when we turn to the courts for justice, further undermining public faith in what is still the best judicial system in the world. She deserves more than shame. So this is just the argument, isn't it? This is the argument in, even if, like we said at the beginning, even if you feel that someone is guilty, are they allowed to have a fair trial? And the argument is still, was Alex Murdaugh's trial fair? Again, I think 99% of people will feel, look, even if we go down this route again, it is just a case of inevitability. It's going to go down the track, and he is going to get found guilty. Are they hoping that there is going to be a different outcome? Are they hoping that they can somehow wing it and win? I don't see Alex Murdaugh being able to escape this. I don't see this being over anytime soon in his attempts to. He is, of course, who he is, and he knows the system very well. But again, let me know down below, do you feel that, despite the outcome perhaps being what you feel was right, do you feel that the way in which they got there was incorrect? And I'd be interested to hear your thoughts again, how this crosses over to the likes of the Brian Kohberger situation. Even if you feel that Brian Kohberger did the crime, but perhaps law enforcement weren't able to attach him to the crime in a proper way, and they may have perhaps utilised methods that they shouldn't have had access to, like with the IGG situation. If you was to find out that that was wrong, would you feel that the Brian Kohberger case should be thrown out, even if you believe that Brian Kohberger is guilty? Or are you just of a mindset that you do what you need to do to get the job done? And is that a dangerous precedent to set? Let me know down below. I'll catch you all in the next one.